Hi everyone, welcome to Cyberlaw's Problems and Solution Part 4. So here the next topic is intermediary includes cybercafe. Now the problem. A mail was received on the mail ID of the Police Commissioner of Pune on 25th August 2012. The subject of the mail stated, "In Ganesha Festival, bomb blast." And the content of the mail also was a threat to police regarding a bomb blast on Ganesh Puja and further challenging the police to stop the attack. The mail, as a result of being objectionable, was sent for investigation to Cybercrime Cell, Pune. A prior investigation was conducted by the informant Dr. Sanjay Tugar, that is Commissioner Pune. Now, the inquiry revealed that the mail was sent from Rajya Computers, Rajguru Nagar, Pune. The cafe was run by accused 2 Sandesh Dere, and the internet connection was registered in the name of accused 1 Vishal Hirman Bhogade. Further, the cafe was not a registered one. The police failed to reach the criminal as the cafe did not maintain records of the visitors, neither procured the email IDs of the users. The informant registered FIR against the accused. The accused were charged for offences punishable under Section 43 subclause G 66 of IT Act 2000 and Sections 188 of IPC. Comment with relevant case laws. So here section 67C, the present problem is based on the state of Maharashtra and Vishal H. Bhogde. So this is a real life case that is based on state of Maharashtra versus Vishal H. Bhogde 2015. So it's a 2015 case. In Information Technology Act 2000, intermediary includes cyber cafe. Cyber cafe means any facility from where access to internet is occurred by any person in the ordinary course of business to the members of the public. As per Rule 3 of Information Technology Guidelines for Cyber Cafe Rules 2011, registration of cyber cafe is compulsory. As per Rule 4, taking ID proof of users is compulsory. As per Rule 5, long register is compulsory. Preserving the information under Rule 4 and Rule 5 for 1 year is compulsory. In the present case, cybercafe was not registered, requisite information was not obtained and preserved. As per Section 67C subclause 1, preserving of retaining the information by intermediary is compulsory. Breach of subsection 1 is punishable as per Section 67C2 of Information Technology Act. Internet connection was in the name of the accused Vishal Bhogde. It was being run by accused Sandesh Dere. Hence, considering the act and rules framed, both the accused are responsible for contravention of rules. Accused Vishal Hiraman Bhogde and Sandesh Soban Dere were acquitted of offence punishable under Section 43G and 66 of Information Technology Act 2000 and Section 188 of Penal Code and were convicted for the offence punishable under Section 67C subclause 2 of IT Act and sentenced to suffer simple imprisonment of 15 days and to pay a fine of 10,000 each. Section 188 of IPC is not applicable when there is a specific provision of Section 67C under Special Act. Section 67C is preservation and retention of information by intermediaries. 67C subclause 1. Intermediary shall preserve and retain such information as may be specified for such duration and in such manner and in format as the central government may prescribe. 67C subclause 2. Any intermediary who intentionally or knowingly contravenes the provisions of subsection 1 shall be punishable with an imprisonment for a term which may extend to 3 years and shall be liable to fine. The condition precedent to applying this section is that there should be an intentional or knowing failure to maintain such information as may be prescribed by the central government. So this is a real life case and it is state of Maharashtra versus Vishal H. Bhogade. State of Maharashtra versus Vishal H. Bhogade. Now the next topic is corporate liability of cyber crimes. Avnish Bajaj, CEO of Bazi.com, a customer-to-customer website which facilitates online sale of property. Bazi.com receives commission from such sales and also generate revenue from advertisement carried on its website. An obscene MMS clipping was listed for sale on Bazi.com on 27th November 2004 in the name of DPS Girls Having Fun. Some copies of the clipping was sold through Bazi.com and the seller received the money for sale. Now here the relevant sections will be section 67 and 85 of Information Technology Act. And this is also a real life case known as the Bazi.com case, that is Avnish Bajaj versus State NCT of Delhi 2005. Avnish Bajaj versus State NCT of Delhi 2005, also known as the Bazi.com case. And it was before the this case came before the Information Technology Amendment Act of 2008. In this case, an internet website, Basi.com, carried a listing which offered for a sale of video clip which was recorded on a mobile phone of two children of Delhi public school indulging in an explicitly sexual act. The petitioner, who was managing director of the company that owned the website, moved to the court to annul his criminal prosecution for the offense of making available for sale and causing to be published an obscene product within the meaning of section 292 of Indian Penal Code 1860 and section 67 of Information Technology Act 2000. So section 67 and 67 of IT Act and 292 of IPC. The petition under section 482 of CRPC also involved question concerning the criminal liability of directors for the offence attributed to a company, both under Indian Penal Code as well as Information Technology Act. So the relevant sections here is 292 of IPC, 67 of Information Technology Act, as well as section 482 of CRPC. Under section 85 of Information Technology Act, which provides for deemed liability of directors. Section 85, which provides for deemed liability of directors in case of offences committed by companies, a director can be held liable without impleading the company as an accused. The court quashed the proceeding against the appellant director, as the company was not even arranged as an accused. The court applied the doctrine of strict construction and took the view that commission of offence the company is an express condition precedent to attract the vicarious liability of others. Thus, Section 85 of the Information Technology Act 2000 cannot make a director personally liable as deemed criminal liability even where company is not named as an accused. So, it is to be noted that this was before the Information Technology Amendment Act of 2008. Section 85 pertains to corporate liability and deals with offences committed by corporate entities. In case a contravention of any provision of the Act or provisions made thereunder is a corporate entity, any person who has ministerial capacity for conducting business of the company is guilty of contravention unless he proves that such contravention took place without his knowledge or he exercised due diligence to prevent the contravention. Such persons are also liable who grant consent or have connived or negligent that leads to contravention by the company. So that was discussed in Basi.com case, Avnish Bajaj versus State of NCT of Delhi 2005 case, that is before the amendment of 2008. Now again, liability of intermediaries. Can intermediary be held liable for cyber offences? Explain the law. Section 79 of Information Technology Act. Section 79 of the Information Technology Act and the Information Technology Intermediary Guidelines Rules 2011. So Section 79 of IT Act 2000 and the rules of IT Intermediary Guidelines Rules 2011. The both are applicable here. Section 79 of the Information Technology Act 2000 covers the aspect of liability of intermediaries, including internet service providers. An intermediary is defined as defined by IT Act 2000 in Section 2 subclause W. So intermediary is defined in Section 2 subclause W of Information Technology Act 2000 as any person who on behalf of another person receives, stores or transmits the record or provides any service with respect to electronic record and includes telecom service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. Now, according to Section 79, that stands amended by the Information Technology Act 2000, Amendment Act 2008, an intermediary is not liable for any third-party information, data or communication link made available or hosted by him except as specified in Section 79, Subclause 2 and Subclause 3. The third-party information is described in explanation to Section 79 as any information dealt with by an intermediary in his position as an intermediary. Section 79, Subclause 2 provides that an intermediary is not liable if it only provides access to communication system over which information is posted by third parties and transmitted or temporarily stored or hosted. The intermediary is also not liable if it does not initiate the transmission, select the recipient, and select or change the information contained in the message. An intermediary is not liable for third-party information which it observes due diligence in performing its duties and complies with the guidelines of the central government. Now, Section 79, Subclause 3 provides conditions when an intermediary is liable for third-party information. Section 79, Subclause 3, Subclause A states that an intermediary is liable if it conspires or abets or aids or induces through threats or promises or otherwise to commit an unlawful act, and the intermediary is also liable if on receiving actual knowledge or on receiving a notice from the government or its agency that any information residing in or connected to a computer resource which is managed by an intermediary is being used to commit the unlawful act, the intermediary does not quickly remove or disable access to the material without vitiating the evidence in any manner. The intermediaries were put under an obligation by central government to take down unlawful content hosted or uploaded within 36 hours of receiving actual knowledge. In Shreya Singhal versus Union of India 2015, Shreya Singhal versus Union of India 2015, however, the court read down actual knowledge under Section 79, Subclause 3, Subclause B to mean receipt of a court order or notification directing intermediaries to remove or disable access to content expeditiously. This proved some respite to the intermediaries who were caught between the issuer of the notice and the users to whom they were bound by the terms of use of their portals. In another case, that is MySpace Inc. versus Super Cassette Industries Limited. MySpace Inc. versus Super Cassette Industries Limited 2016. The High Court of Delhi held that the intermediaries could be held liable only when they failed to take steps to have an infringing content removed from their website after having actual or specific knowledge and not mere awareness or constructive knowledge regarding the contents. The court observed that since the intermediaries only serve the purpose of being a conduit or channel or medium or platform for exchange of information amongst the users, they cannot be expected or equipped or obliged to pre-screen and verify all such information or content that is stored in their website. So that is discussed in MySpace Inc. versus Super Cassette Industries Limited 2016, and the previous case Shreya Shrinkal versus Union of India is a 2015 case. The Bazi.com case came in 2005, that is before the amendment of 2008, and Shreya Singhal case, Shreya Singhal versus Union of India and MySpace Inc. versus Super Cassette Industries both came after the amendment which reduced the liability on intermediaries. Now, liability of internet service provider or intermediary of online infringement of copyright. Now, A uploads a copyrighted work on the website of intermediary X and Company. Objection was raised by B that it was his copyrighted work and there was an infringement of his copyright. The question is whether X and Company can be held liable. To answer this question, we need to know who is an intermediary, who what an online infringement is. Now, an intermediary is a person that offers access to internet and other associated service. So, as discussed earlier, the liability on intermediary has been reduced after the 2008 amendment and it is subject to section 979 of IT Act and subclause 2 and subclause 3. It depends on whether the intermediary has managerial control over it. Further, it was also held in MySpace Inc. was a Super Cassette Industries Limited 2016 that where the court observed that since the intermediary only serves the purpose of being a conduit, channel, or medium or platform for exchange of information among the users, they cannot be expected or equipped or obligated to pre-screen and verify all such information or content that is stored in their website. However, the intermediary becomes liable if they get a notice from the government or they come to the knowledge of such an unlawful act and they do not restrict or take down it without vitiating the evidence, then the intermediary will be liable. So that is with respect to Section 79 of IT Act, and the relevant case laws is against Rayas Wrinkle versus Union of India of 2015 and MySync Inc. versus Super Cassette Industries Limited of 2016. Now, another case law with respect to this, that is the liability of internet service provider or intermediary for online infringement of copyright. Here, in case where a fake profile of Indian resident is created on the Facebook, the police issued the notice to Facebook under Section 91 CRPC within 1 month of the note of the offense to provide the IP address and data of the fake profile. Facebook does not provide the data of the frivolous ground. On the frivolous ground, police files the charge sheet against the offender and also making Facebook liable for abetment. Facebook contends that it is protected under Section 79 of the IT Act 2000, being an intermediary, whether Facebook would succeed. Also discuss the relevant provisions and rules. In this case, Facebook as an intermediary has the protection of Section 79, but the Section 79 subclause 3 also states that when there is a request to take down or restrict avoid the access for unlawful purpose when a notice is served and the intermediary does not act upon the notice, then the intermediary becomes liable. So here it depends. The Facebook cannot take a complete defense that they are not liable because they did not take down within 1 month of the offense to provide. They did not provide IP address or data on their fake profile to the police. That is, they are liable to do that. Now, criminal defamation and intermediaries. There is no exemption of any criminal liability in respect of a company which is a juristic person. In case found guilty, the petitioner company can be awarded appropriate punishment, though not corporal punishment. Explained with the help of Google India Private Limited versus Vishaga Industries Limited. So here the case law is given in the problem itself, that is Google India Private Limited versus Vishaga Industries Limited. So in other words, it's directly asking us to explain or discuss the case of Google India Private Limited versus Vishaga Industries Limited, that is a 2011 case. Here, the facts of the case is that an article was published by the coordinator of Ban Asbestos India, a group hosted by Google, defaming the complainant, a public limited company engaged in the business of manufacturing and selling asbestos cement sheets with 7 manufacturing plants and more than 25 marketing offices all over India. The article dated 31/7/2008 captioned Vishaga Asbestos Industries making gains. It was hence argued that the asbestos cement sheets have been manufactured for more than 70 years in India. However, the complainant was singled out, though there are other groups manufacturing asbestos cement products. Google India had argued that it was not the intermediary and that the intermediary is the parent company. A suit was filed before the lower court where it was alleged that Various articles contained defamatory statement against the complainant, Vishaga Industries Limited, were available on Google's website for a worldwide audience. The complainant took the plea that it was brought to the notice of Google that defamatory statement was published on its website, but it did not block the information as per Rule 3 Subclause 4 of the Intermediary Rules 2011. Rule 3 Subclause 4 of the Intermediary Rules 2011. The petitioner was held liable for offense of pun, liable for offences punishable under sections 120B, 500, 501 and 34 of IPC 501. So that is for seditious matter, defamation, and joint liability. So 120B, 500, 501 and 34 of IPC. Google India Private Limited filed a writ petition before the AP High Court that it is an intermediary, so it cannot be held liable for defamation. According to Andhra Pradesh High Court, dismissed Google's petition contending being intermediary, it cannot be held liable for defamation. The court held that there is no exemption of any criminal liability in respect of a company which is a juristic person. In case found guilty, the petitioner company can be awarded appropriate punishment, though not corporal punishment. So that was held in Google India Private Limited versus Vishaga Industries Limited 2011, with here the Andhra Pradesh High Court said that there is no exemption of any criminal liability in respect of a company which is a juristic person. In case found guilty, the petitioner company can be awarded appropriate punishment, though not corporal punishment. Now, Google India Private Limited versus Vishaga Industries 2019 SCC. So this was from the High Court. The decision came in 2011, and in 2019 SCC Online SC 1857 it is given. Here the Supreme Court bench of Ashok Bhushan and K.M. Joseph had asked Google India to face trial in a 2008 criminal defamation matter and has held that Section 79 of Information Technology Act 2000 prior to its substitution did not protect an intermediary in regard to the offence under Section 499 or 500 of the IPC. Section 79 of the IT Act prior to its substitution exempted network service provider from liability only on proving that the offence or contravention was committed without its knowledge or that he had exercised all due diligence to prevent the commission of such offence and contravention. The first accused is the originator as defined in the act of the allegedly defamatory matter, and the first accused is not only the author but is also the publisher of the alleged defamatory matter, and again proceeding on the basis that it is the appellant who is intermediary and not its parent company. The refusal on the part of the appellant to remove the post may amount to publication. So that was decided by the Supreme Court in 2019. That is the same case by the Supreme Court. Now, the Supreme Court said there may be publication within the meaning of Section 499 of the IPC, even in case of an internet operator, if having the power and the right and the ability to remove a matter upon being called upon to do so, there is a refusal to do so. Now, considering the facts of the case, the court noticed that proceeding on the basis of the assumption that the appellant is the intermediary and it stood or alerted by the complainant by letter dated 9/12/2008, the appellant has not removed the offensive post though it could technically remove it. Therefore, it announced the publication, and publication attracts Section 499 of IPC. The court noted that in Shreya Singhal versus Union of India 2015, the provision were read down to mean that Section 79, Subclause 3, Subclause B of the Act and Rule 3, Subclause 4 of the rules would require an internet service operator to take down third-party information not on mere knowledge or objection to its continuance, but after there has been an impartial adjudication, as it were, by a court. However, in facts of this case, the acts constituting the alleged offence under Section 499 of IPC were done not even not even when Section 79, after its substitution, was in place. The rules were enacted in the year 2011. Thus, Google India was held liable here by the Supreme Court. Now, another problem, that is CompuServe was an online company providing access to over 150 special interest forums comprised of electronic bulletin boards, interactive online conferences, and topical database. A newsletter called Rumorville was made available via the bulletin board. The plaintiff sued CompuServe for libel after allegedly defamatory statements were disseminated through the newsletter against it. Cubby argued that the court should consider CompuServe to be publisher of the alleged defamatory statement and thus hold it liable for statement. Comment with relevant case laws. So here the case Cubby Inc. versus CompuServe Inc. is discussed. That is a 1991 case. Cubby Inc. versus CompuServe Inc. Serve Inc. In the above case, court held that CompuServe had no more editorial control over such publication than does a public library, bookstore, or a newsstand. The court instead found CompuServe to be more akin to a distributor rather than a publisher. Thus, because it was undisputed that CompuServe did not have knowledge of or reason to know of the allegedly defamatory statement made in the publication, especially given large number of publications it carries and the speed with which publications are uploaded into the computer banks and made available to CompuServe subscribers, the court held that CompuServe could not be liable to Cubby for defamatory statement. The court noted that to impose CompuServe the duty to examine every publication it carries for defamatory statement would impose an undue burden on the free flow of information. There was a similar case, that is, Mr. A received an email containing defamatory content regarding Mr. B and told the same to Mr. B. Mr. B filed the complaint with the police alleging the content to be defamatory and offensive. Police refuses to register the case on the ground that offense falls under Section 66A of the Information Technology Act, which has been declared unconstitutional by Supreme Court in the judgment of Singhal versus Union of India. Discuss the provision of Section 66A and the grounds on which it has been declared unconstitutional by Supreme Court. What are the alternative remedies available to the victim of such misconduct? Whether any other offence apart from Section 66A is made out under provisions out of Information Technology Act. Refer relevant provisions of law. So here Shreya Singhal versus Union of India struck down 66A and held it unconstitutional. So with respect to the Shreya Singhal versus Union of India, the court read down actual knowledge under Section 79 subclause 3B to mean a receipt of a order or notice, etc. So in this case, it was also said that when the notice of defamatory content is given, the intermediary has a liability to take down or remove that material, and the police cannot uh, the only 66A is struck down, but the police can file case under 499 or 500 of IPC in such a matter. So that is with part 4 of cyber laws and problems and solution. There is further many problems that is related to e-commerce, etc. E-commerce and intermediaries. Then section 79 counterfeit products sold on e-commerce website and so on. So I will try my best to complete all the parts as soon as possible for people who are preparing for the upcoming exams this semester. That is the end of this part. Thank you everyone. So like, comment, share and subscribe. Do let me know your feedback in the comment section and stay tuned, stay updated. Have a good day. Take care and bye.